we have to fear is
in war,
fear itself.
there is no substitute for victory.
Let us never negotiate out of fear.
We stand undivided, forever united, fighting hand in hand for the liberty we've earned, for glory and honor, for our sons and daughters, ever mindful of the lessons we've learned. Let the torch of freedom burn.
President Thomas Jefferson said, "I know no safe depository of the ultimate powers of the society, but the people themselves. And if we think them not enlightened enough to exercise their control with a wholesome discretion, the remedy is not to take it from them, but to inform their discretion by education. This is the true corrective of abuses of constitutional power."
Welcome to WallBuilders Live with David Barton and Rick Green. It's Thursday, Foundations of Freedom Thursday, and that quote from that young man there is exactly right. It is the people. We're the ones that have to get educated about our constitutional rights, about our freedoms, if we're going to make sure that they're preserved and protected for the next generation. That's why we love talking about these things on Thursday, David. Going back to the foundation, going back to the original documents and the original intent of those documents, that's the only way we're going to be able to save the country.
And that's what kept the country going good for those 226 years that we've had under the Constitution. And we've had more difficulty in the last... We came to a constitutional crisis one at a time with secession, where half the nation walked off. And by the way, can I talk about something just for a moment? This is not part of what we were going to do, but we've talked in recent weeks about how the president has refused to faithfully execute the laws of the land. Yeah. And how he has not followed the law. He hasn't followed the War Powers Act, the immigration laws, hadn't followed the National Defense Authorization Act, the Conscience Protection laws, hasn't followed so many laws, the welfare laws, etc. And what he's chosen to do, and I'm going to throw this out and we'll see what happens, he has chosen to nullify the laws with which he disagrees.
Wow. The very thing that we've been saying is wrong for a state to do, the president's been doing it.
And see, this is why we were saying it was wrong for the state. Back before the president did all this, people said, oh, you need to nullify, use nullification. And I said, no, if it's a constitutional tool, it works in both directions, which means that if we passed a law banning Roe v. Wade, California could nullify it. Means that if we passed a law providing that you cannot limit handgun use, New York would nullify it. They would come in and nullify the stuff that they disagree with. Nullification is not a constitutional principle. What the president has been doing for the last year and a half now is nullification. And this is and our guys don't like it. He can't do that. He can't decide which laws he's going to follow and not follow. Hey, that's what we said when we took a position against nullification 4 years ago.
That is a great point, man. I hadn't even put that together. I hadn't even thought about the fact. That's why, you can feel it in your gut when you talk about what he's doing against the Constitution and on his own making these decisions. It just doesn't feel right, You just feel deep down that's not right. There has to be a rule against that. It has to be violated. Well, that's what nullification does. It makes you feel like there's this arbitrary one person, or in the case of a state nullifying, one state making the decision on their own instead of a true republic where everybody's representatives have a voice.
And that is not the rule of law when you do that. That's the rule of men, the rule of opinions. We're getting closer to a democracy, away from a republic. But I said that because this is a difficult time in America. I mean, we need to know the Constitution. There's been another constitutional crisis in our history, and that was at the time of secession when nullification went wild. I mean, secession was wild use of nullification. The southern states decided to nullify what the northern states wanted to do, and that didn't work out so well. And so we're now back to that use of nullification again.
And actually, they weren't just nullifying what the northern states wanted to do. They were nullifying what the nation as a whole had decided and what the president had been elected by them and Congress had done. Yeah.
That's right. It was nullification of stuff they didn't agree with. And when you do that, you're not under the rule of law. And so we're back to a similar point. I'm not saying secession, but a similar point where that nullification is again running rampant and people are choosing what they want to do and what they don't want to do rather than following the rule of law. And this is just an interesting time in our history. It's a time when we really do need to know the Constitution more so than any other time because that has been our guiding light for those 226 years. If we'll use it, it'll still continue to be a guiding light because it's not built on specifics. It's built on principles. The principles are timeless. If we'll use those principles, they'll still work today. They'll work 1,000 years from now. they'll work anywhere they're tried because they're tried and true principles.
Timeless principles of freedom, and that's what Foundations of Freedom Thursday is all about. Us talking about those. We're going to take a quick break. When we come back, we're actually going to pick up on David. We had a question a week or two back from one of our listeners, and it was about the courts, Article 3, and dealing with what the powers of the courts are, when we can get rid of a judge, what is good behavior, and we covered part of that. But his question also asked, how do you get rid of a court? How do you disestablish a federal court? When we come back from the break, we'll get that answer from David Barton. Stay with us here on WallBuilders Live.
Thomas Jefferson said, "The constitutions of most of our states and of the United States assert that all power is inherent in the people, that they may exercise it by themselves, that is their right and duty, to be at all times armed, and that they are entitled to freedom of person, freedom of religion, freedom of property, and freedom of press."
I'm Professor Radisson. This is Philosophy 150. Fill in the papers I've just given you with 3 little words. God is dead.
When your faith is tested, would you fight for what you believe?
I actually believe in God.
To me, he's not dead. He's alive.
God's not dead, he's surely alive.
God's Not Dead, the movie. Join the movement at the box office and say, God's not dead. He's surely alive. Now playing. Rated PG. For more information, go to godsnotdeadthemovie.com.
Let the torch of freedom burn.
Samuel Adams said, "The liberties of our country and the freedom of our civil constitution are worth defending against all hazards, and it is our duty to defend them against all attacks."
Exactly right. That's why we're learning on Thursdays about those foundations and how to defend those freedoms that we have. And David, last time we covered this topic of the courts in Article 3, we spent some considerable time on good behavior and specific actions where you would remove that particular judge. But I think the question that we didn't answer was, how do you disestablish that actual court? So if you've actually got a district court or a court of appeals that's been set up by Congress, how do you disestablish it, or can you remove it?
This is a question from Tim Barge in New York, and I've got to say, I love these questions, man. We get really sharp questions from folks, and we really do appreciate it because it really does get us into things that people are thinking and allows us to address those things and helps teach the Constitution at the same time. So Tim had 2 great questions. We did an entire program on what is good behavior in a judge and went through and looked at that, and it's a really simple thing. And by the way, good behavior was out there so that you could have a standard by which other judges could see, and if they wanted to keep themselves out of trouble, they wouldn't cross that line of bad behavior as determined by Congress. One of the ways that this can be done easily today, and this is just a little follow-up on that good behavior, you don't have to impeach a judge to make a statement and make an example. You get a judge that makes a really stupid ruling, which happens from time to time. We get some really good judges and some that obviously are there because they wanted to be legislators, but they didn't want to have to go through an election. So they're there making policy. All you have to do is Congress just has to have the Judiciary Committee convene and just hold a hearing on that judge. Have that judge come sit at the hearing and explain to us the logic by which you reached this convoluted, twisted decision, which clearly violates federal law as well as the Constitution itself. And that judge does not want to be there. He does not want to be in front of the cameras. He does not want to be in front of a hearing. And every other judge who sees that, you don't have to impeach him. He can go right back. But you have made an example, and every other judge who sees that says, I don't want to get called in front of, I don't want to be in front of the cameras. I don't want to have to, that committee, 25 guys asking me questions, and so many of them are attorneys, and man, my gosh, I could get really embarrassed trying to answer all the questions they ask because they'll be fully prepared. And it's so
Man,
often,
that is an interesting point, David. I hadn't thought about that when we talked about good behavior. We talked about impeachment and how do you respond. I hadn't thought about, so these hearings, I mean, even if they didn't actually impeach that judge, just calling them on the carpet, that also shows, remember how we talked about that show of authority of actually showing you who's in charge? Just having the hearing itself could reestablish the authority that Congress was given by our founders and the people through the Constitution over the courts and holding them accountable. Have we ever done this?
No, but it's easy to do. It's a constitutional process that can be done. Thomas Jefferson, I think on 3 occasions, said impeachment was a scarecrow. It is what you set up to scare off others that would do damage or do harm. And so it can be done that way. And see, what would be really embarrassing for a judge, and I don't think most people realize this, but very few judges write their decisions that they hand down. They have clerks do that for them. They have clerks to research, and so the judge sticks his name on it. He reads it. If he agrees with it, he puts it together. Usually it's the clerk that does all the work and effort. So you stick a judge in the position of being in front of 25 congressmen asking questions, many of whom have been judges themselves or prosecutors or others, and you're going to find out, that judge doesn't know very much. This is a real embarrassment for him to be here in front of the camera. And nobody else is going to want to go through that process. They don't want to be embarrassed like that, so they will keep themselves confined. Self-control will kick in, and they will have what they need to be able to do the right thing and ruling. So good behavior. I mean, again, there's so much writing on this from the Founding Fathers, so much example of judges that were impeached for lack of good behavior. That's a question that really needs to be rekindled in our minds today, that this is something we can do. The other question about disestablishing federal courts, that's a great question. We'll go to a different part of the Constitution to deal with that, but that's going to be a fun one to look at as well.
All right, we're going to find out how Congress might have the power, and can they, and have they ever actually disestablished a federal court under Article 3. Stay with us right here on WallBuilders Live.
President Calvin Coolidge said, "The more I study the Constitution, the more I realize that no other document devised by the hand of man has brought so much progress and happiness to humanity. To live under the American Constitution is the greatest political privilege that was ever accorded to the human race."
Hey friends, this is Rick Green, and I want to share with you a phenomenal opportunity for your family. David Barton and I both have family members experiencing this right now. It's called College Plus, and it is the best program out there for saving your family a tremendous amount of money on college education for your children, but more importantly, years of their life, and getting them in touch with their purpose, their greatest calling that God has on their life right now. And this is not some mail-order college degree, folks. I'm talking about getting your degree from places like Liberty University or Concordia University or Bryan College, great colleges and universities, and other ones as well. My son Trey's doing it right now at only 16 years old. He's already a sophomore in college. It's been a phenomenal experience for our family. No age requirements, folks. You can do College Plus as well, regardless of your age. You got to check it out right now at wallbuilderslive.com.
Let the torch of freedom burn.
Abraham Lincoln said, "We the people are the rightful masters of both Congress and the courts, not to overthrow the Constitution, but to overthrow the men who pervert the Constitution."
Thanks for staying with us here on WallBuilders Live. It's Foundations of Freedom Thursday, and this week we're talking about the courts, talking about Article 3. David, we talked a little bit about the whole good behavior issue and removing a particular judge. So what about a specific court and disestablishing a court that Congress set up?
Well, let's go to something in Article 1. It's a great way the Constitution says this. Article 1 is what lays out the powers of Congress. Article 2, the powers of the executive or the president. Article 3, the powers of the court. So let's go to Article 1, which is under the congressional section, and it says that Congress shall have the power, quote, to constitute tribunals inferior to the Supreme Court. So Congress is given the authority to create courts lower than the Supreme Court. Now, why does the ability to have a Supreme Court not appear under Article 1? And it's because the Supreme Court, unlike other courts, is not created by Congress. The Supreme Court is created by the Constitution, not by the Congress. So Article 3 exists to say there is a Supreme Court, but that's the only court that the Constitution establishes. Any other court other than the Supreme Court goes back to Article 1, which is the right of Congress to establish that.
So they actually set up how many district courts or appellate courts, not the Supreme Court. It's the Congress that puts those things in place.
Well, Congress even does more than that. For example, if you read the Constitution and you look, let's talk just at the Supreme Court, constitutionally established, authorized by the Supreme Court, Article 3. According to Article 3, how many justices are there on the U.S. Supreme Court?
It's up to Congress, right? Because it doesn't say.
Yeah, there's no the Congress gets to decide how many justices. Okay, according to Article 3, what is the pay that each justice on the Supreme Court receives?
No amount. So I guess it's set by Congress. In fact, I guess it says that Congress sets it.
Set by Congress. Okay. So according to Article 3, there's 4 or 5 issues that are called original jurisdiction. According to the Constitution, what other issues can come before the Supreme Court other than original jurisdiction?
Only those that the Congress decides.
Exactly. It keeps going back to Congress. Even though the Constitution says there will be a Supreme Court, Congress gets to define it. There will be a Supreme Court. Is it going to have 1 justice or is it going to have 48 justices? Are they going to make $28 a year or are they going to make $485,000 a day? That's all up to Congress. Congress is the one who really sets that branch into being. Other than the original jurisdiction things of the Supreme Court can hear cases between states, can hear cases between the United States and another nation. Other than that, the Supreme Court is told what it can do by Congress. If Congress wants to allow abortion issues to come before the Supreme Court, Congress can do that. If it doesn't want to, it doesn't have to let it. If Congress wants to allow military issues to come before the Supreme Court, it can allow it. But if it doesn't want to, only original jurisdiction issues, and there's only a handful of them, that's the only thing the Constitution gives to the Supreme Court. Everything else comes from Congress. So that's the first thing to recognize is Congress really does have control over the Supreme Court. Now, I love the way that our friend Congressman Steve King of Iowa says this. He says, constitutionally, Congress can reduce the Supreme Court to nothing more than Chief Justice John Roberts sitting at a card table with a candle. And that's exactly right. If we decide there's only going to be 1 justice and that justice is the Chief Justice and he doesn't get any staff and he doesn't get a building and all he gets, he doesn't even get electricity, he can have a candle and a parchment, that's all, that's fine. That is constitutional under the Constitution to be able to do that. So that's the first part. So that's why in Article 1, Section 8, it says that Congress can constitute tribunals inferior to the Supreme Court. In other words, below the level of Supreme Court. Now, there's one other time that word inferior is used in the courts. And in dealing with Article 3, Section 1, it says the judicial power of the United States shall be vested in 1 Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. All you got to have is that 1 Supreme Court. Past that, the rest of them exist at the will and pleasure of Congress. If Congress decides that it wants to have 1,000 courts, it can. If it decides that we're tired of 1,000 courts, we don't want any courts, it can do that as well. So whatever Congress ordains and creates, Congress can take away. That's the problem with health care. It's given by the government. The government can regulate it. The government can take it away. Any government-given right can be regulated and removed by the government. Only inalienable rights that are given by God cannot be touched by the government. And the same with constitutional rights. If there's a clear constitutional right, like to have a Supreme Court, Congress can't touch that. Now, it can't say what judges can and can't do on the court, but it can abolish the court because the Constitution established it. That's
but
the
it
same.
can abolish the lower courts.
It can abolish all lower courts, and it can abolish the staff on the Supreme Court. It can the Constitution does say you cannot reduce a judge's salary while he's on the court. So you can say, well, we're going to let this judge keep making $100,000 a year, but all new justices coming on the Supreme Court get $25,000 a year. I mean, that's fine. You can do that. You can't diminish it while they're on the court. You can't punish them economically, but you can decide everything else that goes on. So that's the bottom line answer. Now, when we come back, we'll give some examples of where this has been done and where Congress decided it didn't want certain courts and took them away, because Congress can do that just as easy tomorrow as it did way back in 1802, 1803, 1799, 1868, and all the other times it's done it.
Well, I'm excited to hear this. A lot of people that are upset with how the courts have gotten outside their authority are saying, what can be done? What can Congress do about it? We're going to find out when we come back. Stay with us here on WallBuilders Live.
George Washington. The Constitution approaches nearer to perfection than any other government hitherto instituted among men.
Hey, this is Tim Barton with WallBuilders. And as you've had the opportunity to listen to WallBuilders Live, you've probably heard the wealth of information about our nation, about our spiritual heritage, about the religious liberties, about all the things that makes America exceptional. And you might be thinking, as incredible as this information is, I wish there was a way that I could get one of the WallBuilders guys to come to my area and share with my group, whether it be a church, whether it be a Christian school or public school or some political event or activity. If you're interested in having a WallBuilder speaker come to your area, you can get on our website at www.wallbuilders.com, and there's a tab for scheduling. And if you'll click on that tab, you'll notice there's a list of information from speakers' bios to events that are already going on, and there's a section where you can request an event to bring this information about who we are, where we came from, our religious liberties and freedoms. Go to the WallBuilders website and bring a speaker to your area.
Calvin Coolidge said, "The more I study the Constitution, the more I realize that no other document devised by the hand of man has brought so much progress and happiness to humanity. To live under the American Constitution is the greatest political privilege that was ever accorded to the human race."
Well, welcome back to WallBuilders Live. It's Foundations of Freedom Thursday, and we're talking about that document, the Constitution, specifically Article 3, how our courts work, and whether or not Congress has the authority to remove courts, not just remove a judge, but actually get rid of a particular court. And David, I'm learning so much about this, and I tell you what, I'd loved a couple years ago when Newt Gingrich ran for president, he talked about a lot of these very things you're talking about right now, and when he talked about Congress getting rid of courts, these law professors were up in the air, man. They were screaming, no, the Supreme Court creates the lower courts. And I'm thinking, wait a minute, I know that's not what the Constitution says. And these are the supposed, geniuses about the Constitution, absolutely out of whack with what the Constitution actually says and how it was designed to work. So let's get to it. Specifically, what has happened in the past with regard to Congress removing courts?
Well, let's go to the second president. John Adams is facing re-election. Vice President of George Washington, Thomas Jefferson was the Secretary of State. Now John Adams becomes the second president. Thomas Jefferson is the vice president. And now the two are running against each other in the next presidential election of 1800. As it turns out, Thomas Jefferson, who is the anti-federalist, wins. John Adams, the federalist, the incumbent, loses, but says, well, we can fix this. We're going to make sure we have federalist judges, and that will give us control. So they come, I think there were 16 federal judgeships at the time. They made it, I think, 33, and they stacked it up with Federalist judges and appointed Federalist judges, and that way the Federalists are going to be in control. Well, Jefferson comes in to the next Congress and promptly passes a law that wiped out all those positions. So one Congress established the positions, the next Congress wiped them out. So it was a very simple creation of Congress, and if Jefferson didn't want them and the Congress didn't want them, they got rid of them, and if John Adams wanted it and the Congress wanted it, they put them in. And that's the way it's been. It was not until the 1880s that we even had courts of appeals. There was no such thing as the Court of Appeals. The Court of Appeals was the jury, and that's a whole different program for a different day. But you didn't need courts of appeals because the jury ruled on both the law and the fact. But the U.S. Supreme Court in the 1890s said, no, we don't think juries should have that much power. I know the Constitution says that, but they shouldn't have that much power. And so they knocked juries down to only deciding the facts and not the law, and that put judges in charge of deciding the law. So they need more judges, so they get courts of appeals. And that's where all the various courts of appeals came from. But you go back even to the Civil War time, there were 3 civil rights amendments passed by the Congress, the 13th, 14th, 15th Amendment. 13 abolished slavery. 14th gave the constitutional rights of every state to the citizens living in the state, including former slaves. And the 15th gave voting rights to former slaves. So there were a lot in the South who didn't like those amendments. They're stuck with abolition and ending slavery, but that doesn't mean we have to let blacks own property. It doesn't mean we got to let them get marriage certificates or own guns or anything else. And so that's where all the Reconstruction laws came in, about 23 civil rights laws that were passed to make sure that blacks could vote, they could have education, they could marry and get marriage license, they could keep and own property and arms and everything else. And there was a federal judge in Georgia who just didn't like the Reconstruction Act, so he just kept setting them aside or ignoring them. These are all congressionally passed acts. So Congress comes in one day, they promptly, I think it was like the Northern District Federal Court of Georgia. And Congress passes a bill one day and says, we abolish the Northern District Federal Court of Georgia, but we are going to keep on the clerk and all the staff on that court. So now that the court's been abolished, the judge is without a spot. They didn't impeach him. They didn't kick him off the court. He just doesn't have a spot anymore. They came in the next day and passed a new act that said, we reconstitute the Northern District Court of Georgia. Well, that means they need a judge. They don't have a judge in that court. So they got rid of a court to get rid of a judge, put it back in the next day, put a judge on it, and there's your court. So this kind of stuff happens all the time in history. Now, we don't do it anymore today because we let law professors tell us what the Constitution means rather than reading it for ourselves. But it really is not a difficult thing in history to find all this documentation and see what the original intent was.
Well, and I love the examples that Newt Gingrich ran on as for president, and I think Rick Perry talked about it, and several other candidates said, hey, let's just get rid of some of these courts that are so out of step, just like those courts that you just mentioned. Ninth Circuit has very often been completely out of step. Now, we've had some interesting positive decisions come out of there the last year or so. We've talked about on Good News Friday.
It's almost scary, yeah.
Yeah, that's the exception to the rule for sure. But there are some things that Congress could certainly do to get the courts back in check if they showed their muscle a little bit. But they've got to show that they have the authority to do that.
Well, they have the authority to do it. They got to show that they know that they have the authority and the willingness to do it, because the authority is clearly there constitutionally to do so. But they haven't shown, first off, a knowledge of the Constitution, and second off, a willingness to exert the force that they do have for fear of being criticized over having done it. And they will be criticized by 95% of the law professors in the United States. They'll go through the roof and say, you can, and it may be high, maybe it's 90%. I think 88% of them are Democrats, so they'd probably be criticized by 88% anyway. Number of liberals, it's probably about 85%, I think, is the last number I saw on liberals in that profession. So they're certainly going to object, but that doesn't mean the people will, and it doesn't mean it's the wrong thing to do just because liberals object to it.
That's right. We ought to be following the Constitution no matter. So thank you for sharing so much with us today, David. Thank you, listeners, for learning about the Constitution. Now you can share it with your friends and family. Make sure you go to wallbuilderslive.com and share those links. Thank you for listening today to WallBuilders Live.
Thomas Jefferson said, "The Constitution of most of our states and of the United States assert that all power is inherent in the people, that they may exercise it by themselves, that it is their right and duty to be at all times armed, that they are entitled to freedom of person, freedom of religion, freedom of property, and freedom of press."
We stand undivided.